For the next session, today we have with us Mr. Juan Camilo Bolívar. We are delighted to welcome you, sir. He is a seasoned regulatory and compliance counsel with over 12 years of international experience spanning digital law, GDPR, and public-private legal strategy. He has served in key legal roles at TikTok, Hermes, and Upfrance, where he led high-stakes contract negotiations, implemented GDPR frameworks, and advised on digital risk governance. A certified data protection officer and university lecturer, Mr. Bolivar currently teaches M&A and digital business at EAFIT University, integrating cutting-edge topics such as AI regulation and fintech law. His multilingual expertise and cross-sectoral insights have also shaped public policy initiatives in Colombia, including sustainable tourism and digital transformation strategies. We are honored to welcome Mr. Juan to share his perspectives on ADR and regulatory landscape in Colombia and to enrich today's discussions with his global legal acumen. Now I hand over the stage to you, sir.
With the due permission from the organizers, before Juan is going to start his wonderful presentation, here Juan is given a compliment, particularly from that particular jurisdiction where you have a privilege for additional 10 more minutes you can just expand the knowledge about the core, that's the soul of Latin America, where Colombia is positioned, and how the stakeholders, particularly when it comes to the promotions of alternative dispute resolution in the jurisdiction, not only focused in Colombia, the vast the geographical boundaries beyond Colombia in the Latin American region. Welcome, Juan, and we are very happy on behalf of KFCRI to have you, because your partnership, which has been facilitated in dual aspect, in person as well as your meddling, and we are very happy along with the university wherein you are promoting this concept within these students. Welcome, Juan.
Thank you so much, sir. Thank you for the presentation. Can you hear me well?
Yes, sir.
Okay, thank you so much. I think we can, I can expand some things about international arbitration, Colombia, and LATAM perspective about this international field. Maybe we can wait a little, 8 minutes until it's 9 a.m. here, because people are aware about the schedule from 9 to 9:25. But I'm honored really to join this global forum that brings together international arbitration leaders, scholars, and practitioners across the globe. As you said and you mentioned, thank you for the presentation. My name is Juan Camilo Bolivar, and I will speak today as a legal scholar, as an international legal advisor. I am a former contract manager for TikTok in Europe, mainly in France and Benelux region, Belgium, Luxembourg, and Netherlands. I work at TikTok for 3 years at the beginning of the rise of technology, of TikTok technology in the world during the pandemic. And currently, I am serving as professor of digital business and M&A at the University of EAFIT in Medellin. As well, I'm advising public institutions, public-private institutions on public-private strategy. So if we are ready to start, I can share my presentation, and let me know.
Yes, Juan. But anyway, before going into your presentation on the perspective Most of us want to know about LATAM, what is actually identified or addressed to be.
Yes. LATAM is a very particular subcontinent. Yes. Across Latin America, we have huge countries such as Brazil, Chile, Colombia, Mexico, and Peru. In terms of comparative institutional landscape in Latin America, we can say that we have a very developed and modern arbitration law. We are inspired on the UNCITRAL model and the best practices of European law, such as France and UK. However, the enforcement, what I see in my practice is that the enforcement remains uneven. It's not like in Europe or other jurisdictions that enforcement with the international convention we have today, it's still easy. Here in Colombia, at least, and is a major problem for Latin America, is that the enforcement can cause several problems of perception of the judge. So while Colombia has a clear jurisprudence on public policy, we can say, we have some exceptions. What we call orden public or public order here, it's subject of interpretation. And this subject of interpretation, it comes very broad, undermining enforcement of foreign awards. So Colombia really stands out for its clarity about enforcement and the respect of international conventions and the hosting of foreign awards, because we have a strong institutional support of the Court of Justice, and we have centers, chambers of commerce that are really doing their job. I'm talking about the Chamber of Commerce Bogota and the Chamber of Commerce of Medellin, the two main cities in Colombia. So actually, they offer digital filing and virtual hearings. What is a trend that we can see since COVID-19 pandemic? And this is the subject that I'm going to talk to you about today, the intersection between tech, arbitration, ADR, and LATAM.
Oh, so nice, Juan. But as a individual, having an aspiration to travel across the globe, when I started into international arbitration, I had that aspiration. Then I took arbitration as a tool to travel across the globe. And after the pandemic, that has been cut shorted, that virtual is the only option. Having said that, any interesting fact about Colombia as a country, looking into its history? Anyway, your presentation, you can just very well start in a couple of minutes. But as an aspirant to travel, there are multiple destinations each and everyone would have. Particularly from my region, everyone would be interested to go to the Spanish part of the Americas. That's what we see the South American countries, except Brazil. What is your say on the country as such, Colombia? And a very interesting thing about Colombia for all of us to be prepared to go to that destination.
That's a very tricky question, sir. Actually, in Medellin, I'm working in tourism, which is a field that is rising in Colombia. Colombia today is, by excellence, the best destination for tourism in Latin America. We, as you know, we got like a social transformation since a couple of decades already. 30 years have passed since we got this transformation in Colombia, and we are hosting, by the way, a lot of international events at the Greater Convention and Visitor Bureau, where I am an ally today. Our mission for the international world is for people to get in love or to fall in love with Medellin and Colombia, because we have a lot of things to offer in terms of biodiversity. We are the most biodiverse country in the world. So what are the main advice and tips? Just come with your best attitude, because Colombian people are very warm, and you will be very, very welcome here in Colombia. In Latin America, we have this particularity. So you are very welcome when you want to come to Medellin. Even we can host this kind of international events for arbitrators and legal practitioners here in Medellin. We have all the infrastructure, and from the public sector, we can get a little bit of help through the Greater Convention and Visitor Bureau that attracts international events to the city, for instance.
Okay, sure. Done. We will be there before the second edition of GSADR of the day. Thank you. Now you can start your presentation, and we are awaiting the insight, what you are going to share about your jurisdiction in the Global South.
Thank you, sir. Just 1 second. So you can see my screen?
Yes, sir.
Great.
Sir, I think you're on mute.
Sorry. So thank you so much for inviting me to this international congress. I'm very honored to be here to talk about Latin America, Colombia, as rising contributors to global arbitration in the age of artificial intelligence, AI. I'm representing Colombia to talk about the legal structure of arbitration in Colombia, but I salute and I thank the Greater Medellin Conventions and Visitor Bureau and the University of EAFIT to be knowledge partners of this event in Colombia. And thank you, you all in India, the Kovise Foundation Conflict Resolution International, and thank you to all the organizing committee for making this possible. We are in a 24-hour virtual event that brings together arbitration leaders, scholars, legal experts, practitioners from across the Global South. And we are very happy in Colombia here that we are fostering South cooperation. So, as I said previously, my name is Juan Camilo Bolívar. And I will speak today as a legal scholar. I have an experience over 15 years working at TikTok, for instance, as a contract manager, during 3 years during pandemic. I'm also a former legal advisor at Hermes Paris, where I used to work for international subsidiaries and advising on contract negotiation, legal structures, M&A, and plus arbitration clauses design. I also work at Willis Towers Watson in insurance sector in Paris. And the topic today is very related with what I like to do, which is data. I'm a data protection officer with a certification under GDPR. So my passion about international business law comes from the University of Versailles in France, where I study my master's. So the topic today of what I'm going to talk about is both timely and complex, because I want to go on the intersection between tech-driven arbitration in Colombia and Latin America. So we are going to see the legal structure, the evolution, and AI and integration today in Latin America arbitration. We will explore as well the evolution of arbitration in Colombia, in contrast with international trends and comparative law here in Latin America. And at the end, we will dive into the legal and ethical implications of international arbitration, artificial intelligence in dispute resolution. I will give you a mini business case about my practice at TikTok, designing transnational clause on the international contracts of the business product data terms of these tech giants and how it works. Because more than a theory, what I'm interested in is to apply this practical side of myself to real problems in Colombia and in Latin America. So, Colombia has the arbitration in Colombia is legally grounded in the Constitution, in the Article 116 of the Constitution of 1991. That's our latest version of Constitution, which allows private individuals to temporarily exercise judicial functions. This constitutional endorsement was reinforced with the enactment of Law 1563 of 2012. So let's say that since 2012, Colombia has a modern infrastructure that talks about international arbitration and domestic arbitration. This is one of the first LATAM legislations that goes into that way. We have to remind, maybe there are other speakers talking about Brazil, but we have to remind that there are other jurisdictions that make no difference between international and domestic arbitration in Latin America, but Colombia does. So they give us a national and international arbitration statute. This statute is a modern Colombia arbitration law and was adopted just taking into account the international principles of United Nations model law, UNCITRAL. So when we're going to talk about this law, this very recent law since 2012, Law 1563, we can say and emphasizes that there are three core principles. The first of all is voluntariness, voluntariedad in Spanish. What is voluntary? Willing. We also have this second principle about temporariness, which are principles of international arbitration law. And the competence. Remember this principle, competence, which is an international principle of international arbitration. And in Colombia, we define and we take these international principles of the United Nations and we applied it in private arbitration or commercial arbitration. This presentation will also be driven towards commercial arbitration. I think that if we can talk about investment law arbitration, we will have to have another presentation. So this is the focus of this presentation. So when the law came into effect in 2012, legal scholars in international arbitration in Colombia were very excited because Colombia was going from the dark to the light in terms of international arbitration, because we understood that defining, for instance, ad hoc and institutional arbitration that will be enabling foreign and domestic awards to be enforced under these standardized procedures. So Colombia has a very good relationship with international law, and we see it on, under the New York Convention. Before we get into the relationship of Colombia and New York and the other international conventions, I will just say, to close the domestic arbitration law, to say that there are some key aspects that Colombia is very different from the rest of countries here in Latin America. These aspects I would say that Colombia treats international arbitration distinct from domestic arbitration. That makes a huge difference. There are some other countries, such as Brazil, they don't. So they have problems to enforcement foreign awards. This gives us flexibility. For instance, flexibility in terms of governing law, flexibility in terms of institutional rules. As I previously mentioned, we have two main international arbitration centers in Colombia that are the Chamber of Commerce of Medellin and the Chamber of Commerce of Bogota. Both of them, they have the ADR and arbitration center. So in Colombia, we have this institutional power that give us the way to be connected with the international principles of arbitration. So Colombia ratified in 1979 and reapproved in 1990 the International New York Convention. For those who are not aware about this international convention, this gives us the possibility to enforce foreign awards in our territory, even if they were not issued here, for instance. There was a very complex constitutional journey to ratify this New York Convention. It had been signed in 1979, but the implementing law was stuck down in 1988. And only after legislative revisions and discussions in the parliament, that was approved. This delay highlights the tension between domestic constitutionalism and international commitments here in Colombia. It's an issue that I would say that is still affecting Latin American jurisdiction. Since 2011, Colombia's Supreme Court has embraced a pro-arbitration posture, applying international standards, very robust, very consistent. We got this evolution since the Supreme Court was aligned with the international arbitration principles. So we can say that Colombia is a member of the ICSID, the CIADI in Spanish, and has been party to multiple investment arbitrations under bilateral investment treaties. Yes, this is an international engagement position that Colombia has, and it's very natural for Colombia to be a hub of international arbitration in the region. So we're moving from one of the most important and strongest contributions of development of hybrid legal doctrine. We can say that some scholars such as Silva, Bustamante, they are revealing that although arbitral awards are not formally binding here in the country, they are increasingly being used as a persuasive precedent in high-stakes sectors, such as infrastructure and energy. These two main sectors in Colombia that are fostering and driving economy. In fact, Colombia is developing a soft jurisprudence framework where consistency and coherence are achieving through citation practice and institutional memory. So, how is the panorama of Latin America? We see countries like Brazil, Chile, Peru, that have also developed modern arbitration law based on the same UNCITRAL model. However, how I said, enforcement remains uneven. While Colombia shall be a legal platform for European and US businesses. Why? Because Colombia has clear jurisprudence on public policy exceptions, for instance. Other jurisdictions often interpret orden public order too broadly, undermining enforcement, as you know, of foreign awards. Colombia stands out because of its clarity. Yes, because we have a strong institutional support from the centers of the chambers of commerce. And now we are using technology to offer digital filing, virtual hearings, as well in the war. But I deeply think that in our countries, in the South hemisphere of this war, we have to use technology to fill the gap of development. And the gap of development also relies on international arbitration practices. So Colombia and the region have a huge opportunity to use the new technologies and the new trends on technologies. Legal text and the rising of legal text here in LATAM is a very important point of that. So when Colombia state the 2012 Colombian arbitration statute, we saw a rise of international arbitrations in the country. Cities such as Bogota and Medellin were hosting more arbitrations. We recognize party autonomy and the principle of competence, and we attended to an enforcement of foreign affairs broadly. I think I have a couple of minutes. So I would love to share with you a TikTok case, because during my tenure at TikTok, I negotiated contracts where arbitration clauses were embedded into the platform commercial architecture. In data protection, we say privacy by design. In this case, arbitration by design. So these agreements of the tech companies, talking about the tech sector, because in Latin America, we are hosting and attending a rise of technologies, fintech technologies, legal technologies. So when these giants of technology come to our region, we can see that these agreements are often mandated by ICC arbitration, Paris arbitration, not Paris itself, but for those who have the opportunity to go to the International Chamber of Commerce, we can say that it's a place where commerce and trade and business are secure. So tech giants like this, they use ICC arbitration, either in Paris or in London, with English law and governing law. Crucially, when talking about these clauses, this contract included data governance clauses tied to controller data regimes, ISO 27001 and ACC's standard commercial clauses were linked to these arbitration clauses. It was a model in which we have a 250K liability cap. We had to negotiate with Christian Dior, Air France, and all these big French and European giants, the arbitration clauses, because partners, they were not sure about the election and the choice of the forum. So my main point is arbitration is being integrated into digital ecosystem from the start. And that's a lesson that we have to learn here in Latin America and in the South, because this model offers a valuable blueprint for Latin America. For instance, platforms based in Bogota, Sao Paulo, Buenos Aires are starting to consider similar clauses. When we talk about governing law in data protection, for instance, we're talking about GDPR and CCPA, California. So what's the lesson that we have from in AI, for instance, to talk about regulatory and an ethical roadmap of arbitration? To govern AI in arbitration, we must look to emerging global frameworks. For instance, the European Union's AI Act entered into force last year, 2024, is the most comprehensive example. We, as a region, we have to go in that way because we have to impose transparency, explainability, and oversight obligations. In arbitration, the Silicon Valley Arbitration and Mediation Center, for instance, and the Stockholm Chamber of Commerce have published practical guidelines in that way. In Latin America, we have to adopt, and we are adopting AI. So Latin America must not lag behind. Colombia has the capacity to pioneer regional standards rooted in proportionality, fairness, and accountability. Colombia is not only complying with international arbitration standards, but is actively shaping them through technology. Uh, I think I have 1 more minute time. Yes. Okay. So my conclusion is our region has a lot of things to put in place in terms of international arbitration, ADR. We are a region that we are leveraging robust legal framework. Yes. We have doctrinal innovation. Yes. We have openness to technology. And we can position Colombia and Latin America more broadly in these international legal scenarios. We can be leaders in fair, efficient, and tech-augmented dispute resolution. So thank you, everyone, for your attention, and thank you to the Kovise Foundation Conflict Resolution for inviting me for this little talk about my region. And I will look forward to continue this dialogue and this conversation with you all if you desire. Thank you so much.
So we have a question in the chat box
Yes.
from Mukesh, which is as follows. With Colombia's rise in international arbitration, how do you see the impact of regional institutions in shaping the country's arbitration landscape?
That's a very good question, because institutional arbitration in the region is what we have the most accomplished. As I previously mentioned, in Colombia, for instance, we have the Chamber of Commerce of Medellin and the Chamber of Commerce of Bogota, which are the two main cities in Colombia that are fostering ADR, that are fostering arbitration, and that are fostering the inclusion of technology into the international arbitration or domestic arbitration proceedings. So we are aware of international changes. We have an opportunity here in Latin America, because we have a lot of relationship with the United States and Europe, and we can be a hub and host these international disputes here, because we have the legal framework as the law of 2012. We have a doctrine innovation and legal innovation that is crucial for international arbitration. And we are into that path of fostering and improving institutional arbitration. I would say that public sector and public-private alliances and strategies are effective here in Latin America, at least in Colombia, to foster arbitration, mediation, negotiation, because we understood that using ADR and arbitration would mitigate the impacts of the burden state of legislative and judicial decisions. We in Latin America, as you know, we have a huge problem of bureaucracy. And bureaucracy means time. And we know that arbitration is time. Arbitration most important benefits is time. And that's what we have to get back from the international or domestic arbitration centers in Latin America. Time.
Thank you, Juan, for the insightful perspective of arbitration in Colombia as well as LATAM, and particularly your past experience as in-house counsel. That's very, very interesting. We will take this quite seriously, and we will, as a part of Global South, the partnership and the Medellin Bureau, all get together along with the universities we can, and we will explore, and whatever the objectives, the 4 objectives of this GSADRT or D would be done. And with your support from that region, really, it will happen. Thank you, Juan. And
Thank you so much.
now I